Excellencies. Good afternoon, Ms. President, Your Excellencies. May it please the Court. My name is Merissa, and I am agent for the respondent in this case, the state of Reverentia. I am joined by my co-agent, Jessup Moot. I will be addressing the first pair of issues in this case, to do with East Agnostica's secession from Agnostica and Reverentia's resolution in support of a popular referendum. My co-agent will take on the second pair of issues in this case, to do with the termination of the Martha Convention and the removal of software from the mining facilities. In respect to the first pair of issues in this case, Reverentia would like to respectfully request the Court to adjudge and declare that Reverentia's referendum was clearly conditional support offered to the people of East Agnostica on the event of a popular referendum demonstrating their will to secede. Nothing in the referendum or nothing in the resolution demonstrates any threat towards Agnostica whether or not the referendum occurs. In other International Court of Justice cases on intervention, such as the case of Nicaragua versus the United States, have found that coercive measures forms the very essence of a prohibited intervention. Without coercive measures, there cannot be a prohibited intervention. In the case of Nicaragua versus the United States as well, it is shown that while force, such use or threat of force, can be done directly by the party, it can also be done indirectly. And in this case, force was neither used or threatened directly nor indirectly. As far as territorial integrity, it is very similar to the issue of intervention. The classical understanding of territorial integrity under the UN Charter, Article 2, Section 4, is that UN members must refrain from the use or threat of force against the territorial integrity of other states. Without the use or threat of force, it is not enough to find an illegal violation of territorial integrity.
How do you respond to the applicant's argument that the whole is more than the sum of the parts? The combination of the resolution and the mobilization of force strongly implies that force is about to be used.
Yes, Your Excellency. I would counter that if you actually zoom out, you can see, if you zoom out on the situation and consider Reverentia's actions towards their ethnic nationals abroad in Agnostica have clearly demonstrated a will to support their ethnic nationals abroad and have not had any territorial aggression against Agnostica. Since independence was declared from the colonies, for the following 30 years, Reverentia called to their ethnic nationals abroad to try to call them back to the territory. Throughout the conflict with Agnostica, with the Martha Convention, Reverentia continually called out to their people to try to ask them to return to the safety of the country. They were clearly fighting for the safety of their ethnic nationals abroad and have no other indications that they have any territorial ambitions in this case. So on the totality of the circumstances in this case, it was clear that Reverentia was simply trying to protect their nationals and had no territorial ambitions.
But the actions leading up to this particular dispute are radically different than the ones following decolonization. Here they bring their troops to the border and they essentially tell the Agno-Revs, we are ready to support you if you bring this plebiscite and declare yourselves independent. Isn't that incitement, and doesn't that impinge on the internal affairs of Agnostica?
Respectfully, Your Excellency, no, it is not incitement. It may be an inducement to the people of East Agnostica to join, to consider their offer, but it is not incitement to violence or any other incitement, illegal incitement on the side of Reverentia. It's clear from the statements of the President to his troops and to the people of Agnostica that mobilizing the troops to the border was to prevent spillover violence from the state of Agnostica into Reverentia. This has been seen in the case where the United States mobilized its troops to the border of Mexico when Mexican drug violence was spilling over into the United States. A country should be allowed to protect its own borders.
You've mentioned before this idea that Reverentia didn't have any territorial ambitions.
Mm-hmm.
But is it necessary that Reverentia had territorial ambitions and it wanted to annex part of its neighbor for the amassing of troops on the border or any of its other actions to be considered an act of aggression?
Just to clarify your question, so is it necessary that they did those actions were there to find a violation of territorial integrity?
Is it necessary that the goal of the actions was to annex part of its neighbor's territory, that there was a territorial ambition for us to find an act of aggression? Is that an element of the act of aggression?
No, it is not an element of the act of aggression, but it is a key element in analyzing the situation in comparison to other international court of justice cases, such as, or in the case, not necessarily international court of justice cases, but other cases of under international law, such as the case of Northern Cyprus, or the illegal unilateral declaration of Northern Cyprus, where troops were moved into the territory and there was territorial aggression before the unilateral declaration was given, or in the case of Crimea and Russia, where Russia made statements that their actions were in efforts to protect their nationals abroad, but also moved unmarked troops into the territory of Crimea to take over strategic positions. So it's clear that in other cases of unilateral secession that have been declared, that have been deemed illegal by international sources such as the International Court of Justice or the UN, that illegal actions like this are typically associated with the use of force or moving troops into a territory.
But what about a unilateral secession where there isn't this sort of third-party character, something like Kosovo, where somebody doesn't come in and help Kosovo or annex it, just sort of.
And the Court of Justice then declared that unilateral secession
declares that it's Kosovo and that it's Kosovo. Why is this not more like Kosovo?
This is similar to Kosovo in that the Court of Justice then declared that unilateral secession is neutral under these cases and must have an associated violation of international law to find the unilateral secession illegal. But as far as, I'm trying to understand your question. You're trying to understand.
So you were making these references to cases where you have the annexation, like Crimea, right, where Russia comes in before the secession and says we're going to have these troops in Crimea. And I'm wondering why this case is more like Crimea than it is like Kosovo, where Kosovo declares independence on its own and then just is Kosovo.
Oh, I would argue that this case is more similar to Kosovo than it is to the situation with Crimea and Russia.
Okay.
The situation with Crimea and Russia is easily distinguishable from this situation because although there was also the case of a popular referendum being declared and the integration of the country into Crimea into Russia, it was done it was all done while Russian troops had been moved into the territory. In fact, when the country when the parliamentary council in Crimea decided to host a referendum, there were actually unmarked troops from Russia in the building at the time that had cut off communications and kicked out independent journalists. So it's clear that we're different from Russia and Crimea because Reverentia never moved troops into the territory until the countries had mutually decided to integrate into one another. Even after the popular referendum was held, Reverentia did not move troops into the territory until East Ignatica decided to integrate into Reverentia. So as far as the legality of East Ignastica's secession from Ignatica, it's clear from previous cases such as the Kosovo Advisory, or in the case of Quebec, the case of the secession of Quebec, that domestic law, such as the domestic law of Ignatica declaring that secession can occur after a 3/4 vote of Parliament, domestic law is not relevant to determining the international law's legality of the secession. The court must look to whether there are attached violations of international law. A few examples of this would be the case of, again, Northern Cyprus and the case of Southern Rhodesia. In both of those cases, secession was an attempt to consolidate a situation created in violation of peremptory norms. In the case of Northern Cyprus, troops had been moved into the territory, and then soon after, those same troops declared independence from the territory. In the case of Southern Rhodesia, the Declaration of Independence was done in pursuance of apartheid politics. In both cases, they were declared to be illegal because they had associated violations of international law, but were not illegal because of the character of the unilateral secession alone. because of
So
the,
is a plebiscite alone enough to constitute a unilateral secession?
no, Your Excellency, the Declaration of Independence that the East Agnostican Parliament held after was what concreted the secession. The use of the popular referendum is simply a measure of increasing the legitimacy of the secession from Agnostica.
So
And
with, if there hadn't been a referendum at all and the semi-autonomous Parliament of East Agnostica had declared itself independent, that would be enough?
In the case of, as seen in the case of Kosovo, yes. However, in this case, we would show that the secession of East Agnostica was legitimized by the referendum in the same way by following the example of the Western Sahara case decided by this court.
Is the Declaration of the Parliament enough to make East Agnostica a state?
Your Excellency, alone to make a state, to make it an independent state, it would traditionally have to follow the Montevideo Convention to show that it has a defined territory, a people, and the ability to enter into relationships with other states.
Well, I mean, presumably, if it seceded, then it would have become a state independent of its treaties.
Yes, Your Excellency.
So did it follow the provisions of the Montevideo Convention?
Yes, it fits the conditions of the Montevideo Convention, Your Excellency, as far as having a defined territory. Since they were already a province of a set province of two provinces in the territory, they already had the ability. They already had the defined territory, the defined population, and the ability to enter into relations with other states. And in addition,
I do want to hold for a second. Is there an international law, accepting that secession is neutral under international law, there's nothing else beyond an act of parliament of an area that fits the Montevideo Convention to creating a new state, seceding out of another state?
Yes, Your Excellency. As seen in the Kosovo decision, a unilateral secession, as seen in both the Kosovo decision, or the Kosovo advisory, and the case of Quebec, the Quebec secession, both courts found that unilateral secession alone is not a unilateral secession, although it is not illegal, is not legally effective either. In order to become a new state and to gain and to truly successfully secede, you must gain the recognition from other states. So this is seen in the example of Northern Cyprus, which to this day is still only recognized as a state by the nation of Turkey. And in the case of Kosovo, there's been limited recognition from other states who sympathize with Kosovo's plight. But again, the true measure of whether a secession is successful and legitimate under international law is the support it gains from other states.
And how many states recognize East Agnostica?
Well, that's one benefit of East Agnostica integrating into Reverentia, as it gets to avoid the issue of gaining recognition from the international community.
But your opposing counsel mentioned that as an argument that if it didn't become a state, East Agnostica didn't have its own state and then join Reverentia, then maybe it was an act of aggression for Reverentia to just sort of take over this part of its neighbor. So if it didn't, get recognized as its own state and then decide to join you, then did you just take over part of your neighbor?
Because it was consensually done, so this issue hinges on whether the secession was successful. And the secession, in the view of Reverentia, was successful because it was done with the consent and the expressed will of the people, which it adds legitimacy to it, and it's required under the Western Sahara case for change in the territorial boundaries of a nation.
But who has to consent to it? If East Agnostica is not a state and it cannot consent to it, then wouldn't Agnostica have to consent to it? And clearly they're not consenting to it. That's why we're here.
It is, yes, I agree. Our case does hinge on whether or not the secession was effective or not.
So we have to address the issue of whether or not East Agnostica actually became a state, whether or not it was recognized by other countries, correct?
It's still, whether or not it's recognized by other countries, that the recognition by other countries simply increases the legitimacy of their new statehood. It is not required in order for the secession to be successful. The secession's success as far as the secession is still effective whether or not other states recognize the territory. The only thing that would impinge upon the secession would be if the court ordered retrocession against the express will of the people. And as Judge Dillard said in the Western Sahara case, an order of retrocession against the express will of the people would violate their self-determination.
But I think the question is still outstanding. We need this to figure out what's going on in this transitional period. It's still part of agnostica when Reverentia puts the troops in. That's obviously an act of aggression. You agree that that's violation of international law, correct?
If the secession was not complete, even so, the Parliament of East Agnostica consented to the troops moving into the territory. So whether
The Parliament of East Agnostica, under those circumstances, doesn't have authority to enter into international relations. It's just part of agnostica.
East Agnostica is its own province, and so it would have the ability to
But the
consent.
state of Illinois can consent to having Canada enter troops into it.
That would be a different situation, Your Excellency. In this case, both of the provinces already had the ability to, both of the provinces were created with the expectation that they would be semi-autonomous, and they were already autonomous before the secession
And
occurred.
part of their semi-autonomy was to give them control over international relations.
No, Your Excellency.
That they don't have the power to consent to the agreement.
Before the secession, Your Excellency. But however, it is the position of Reverentia that the secession was effective, because again,
But then
secession.
my co-excellency's question is still outstanding. What happens if the secession isn't valid?
I'm sorry if I wasn't clear when I answered that before. Our argument does hinge on whether or not the secession was valid, and it is the position of Agnostica that international law views secession neutrally, and that it would not be illegal in this case. It was effective.
And then we, just to bring it home, and then I'll let you move on. There needs to be you've stated that there needs to be something more than just a vote of the local parliament to create a new state and thus complete the secession. And to do that, does there have to be international recognition, or doesn't there?
No, Your Excellency. A declaration of independence on its own is effective at seceding the territory.
So if the General Assembly of Illinois votes that it is no longer part of the United States, it is its own state, and Canada can take over if Illinois agrees.
If Illinois, the population, or if Illinois, the acting parliament.
The
I guess I
General
would say,
Assembly
yeah.
and population, we all agree Canada can come in and take over. Is Illinois its own state without international recognition?
Each state of the United States has the ability to secede by choice. It is, I know that in reference to the issue of Kosovo, it was highly debated within the United States whether individual states wish to secede. So yes, it is possible for individual states within the United States to secede from the United States. Since I know I am low on time, I will just reiterate why the court should not order a retrocession against the express will of the people. A retrocession would again violate the self-determination of the East Agnostican people, which has already been expressed through the referendum. The referendum was declared free of irregularities and interference by various different observers from non-governmental organizations, and it had nearly a 3/4 vote in favor of seceding from Agnostica. As in the Western Sahara case, Judge Dillard noted that a people should be free to determine the destiny of a territory, not the territory the destiny of the people. In this case, it's clear that the people of East Agnostica wish to secede from Agnostica, and that wish should be respected. An order of retrocession would result in limited access to Marthite, result in more